Hi there, this is Billy Tarasio with the Modern Divorce Podcast, back with another episode with Darren Colburn. Hello, Darren.
Hi, Billy. How are you?
Oh, good, so good. Now, you would think that we would be talking about the Bill and Melinda Gates divorce because that is what everyone is talking about, but we're going to talk about something a little similar, but not exactly on point. We're going to talk about family businesses. And when people own a business, when one party owns a business or both people own a business and you go through a divorce, and what happens to the operations of the company. Because, of course, that is going to be affecting Bill and Melinda Gates, who were both working, in their foundation, both owning their foundation. Now, sometimes one person owns and one person doesn't, but it can get really tricky and really messy to figure out how to operate a business during a divorce.
It sure can. So the first question with any business valuation case is, when was the business formed, right? At least in Arizona, because Arizona is a community property state. And this question is important because if a business was formed prior to the marriage, then it is maybe considered sole and separate property, and that would certainly impact the extent of the other spouse's interest. Um, if it's open during the marriage, it's presumed to be community property, which would be subject to an equitable division. Now, as we'll kind of discuss later, if you have a spouse who started a business before you got married, you're not necessarily your claims aren't necessarily zero. There is something called a community lien theory that you can use to assert to obtain an interest in any growth that occurred during the marriage. But I think it makes sense first to talk about a scenario where there's no dispute the business is community. So in this, yeah.
Yeah, and so I'm glad that you brought that up, because from the family law perspective, like, that's the analysis. The first question is the business community or separate property? That's what we do with all pieces of property in business. But the other issue with businesses is that businesses are also governed by their own rules, their operating agreement, their ownership structure that is different from whether or not the community has an interest. And so one of the other things that we have to do when we have a business is we have to figure out, well, who owns the business, who's a member, or who's a director, who has the authority under the business statutes, which are Title 10, to control and operate in the business.
Right, and that's a good point. And I guess it's worth stating that business owners and operators can contract for whatever they want, I mean, within reason, as far as how things work within the business, how it's managed, how it's governed. In the absence of an operating agreement or a formal written agreement that outlines those types of provisions, their Title 10 and the default statutes will control. So whether or not you have an operating agreement, there's a procedure in a set of rules that govern the operation of a business.
So, and this comes up a lot of times with houses. Like, if somebody owns a house before they got married, but then they refinance it and they put the other person on the title, then we've got some competing things going on, because our general family law analysis is, well, it was owned before the marriage, so it's separate property. However, once you put both persons' names on it, then it looks like it's been gifted from separate property to community property. Is the analysis the same with a company?
I think it's similar, but slightly more complicated than the titling of a house. Usually when a spouse is added to the title, that's pretty definitive proof that it's intended, even if it's not technically community property, they both have an equal interest, which is essentially, as far as outcomes, going to result in the same thing. And a similar argument, I think, can be made as far as corporations, in terms of a person being added as an owner or a member. Now, usually when you're added as a member, you're taking a certain defined stake in the company, and if that stake is not explicitly defined, it may just be an equal share with the other members. But it's worth noting that some businesses aren't all community, meaning, one spouse, your husband or your wife may start a business with third-party partners. Maybe it's a friend, maybe it's a family member, maybe it's a peer or a colleague, and maybe the community only has a fractional interest in the company. Maybe it's 50%, maybe it's a third, maybe it's any other number, right? In that case, you need to determine the value of the business as a whole, and then define what portion of that value belongs to the community.
Sure. And one issue we've got is value. What's the buyout? But the other issue we've got is control. So let's say that one spouse is the owner, the member of the LLC. And let's say they own it by themselves, but it was started during marriage. Now, this is a community business, right? And many times when you go forward and you talk to the judge, and they think of a community business, you can get into a situation where, is the owner spouse allowed to cut out the non-owner spouse, or does that violate our preliminary injunction?
Well, I think it depends on, so these questions are very complicated, and it depends on what the impact of the decisions are. First of all, and you kind of put this in your fact pattern, but the answer to this question may be different if both spouses are members of the of the corporation, because the limited liability rules or limited liability company rules in Arizona recently were amended to include a fiduciary duty between members, which is important to understand because you're not necessarily allowed to do to take actions which would harm the other members or the corporation as a whole. Whereas the preliminary injunction really just kind of preserves the status quo and prevents you from transferring, concealing, or otherwise dissipating assets outside the normal course of ordinary course of business. So you have a lot more leeway under that statute than you would under an obligation that's fiduciary in nature, which is a higher standard. If you're not a member, there's no fiduciary duty. So the court is looking at, are you dissipating the value of the company? Meaning, are you being, let's say you go out and you tell all of your clients that you're going to start a new corporation under a new entity, and they should start doing business with that entity. And all of a sudden, you're basically just transferring the revenue stream to a different entity to try to cut your spouse out of value. That would be a problem, right?
Yeah. And so that's a great point. And I want to talk about that. One thing that a business owner needs to be careful about is, just because you run your business into the ground during the divorce does not mean that you won't have to buy out the other spouse, because the date of the valuation is the date of the service to your business. So that works both ways. On the plus side, it means you are free to grow your business and you won't be penalized by having to buy out the other person, because it should be valued as of the date of service. On the other hand, there is no benefit to you in running your business to the ground or opening a competing business and transferring all the customers, because it's going to be valued as of the date when the customers still belong to the community business.
Right, that's a good point, and I hear that a lot. Well, especially with businesses that are more service oriented, because the owner or operator spouse often thinks, well, there's no business without me, so I'll just stop doing work, and then there's no value. For the reasons you described, that doesn't work. The valuation is typically going to be as of the date of service, although not always, but that's the general rule.
We should talk about that. Yeah. Why is that not always the rule?
There's a couple of things. If certain transactions or major fluctuations in value are prospective, meaning they're going to occur in the future, and they were foreseeable at the time of divorce, then or at the time of service, then the court may use that later valuation date. For example, you could have deals in the pipeline that are anticipated to go through,
Mhm.
highly probable, but not yet official, it
Mhm.
would be inequitable to not consider those. Um, on the other hand, if you look at like the pandemic, for example, um, that depending on when you filed for divorce during COVID, maybe it was or wasn't foreseeable, right? So if you filed for divorce in like November of 2019, uh, you really can't go back and argue that the value of the business should be less because of the pandemic, because none of that was foreseeable. If you file for divorce in April, um, maybe that's a different story, right? So, but really foreseeability is the key factor there. Also, it depends on the nature of the business, because businesses, some businesses sell goods, some businesses sell services, some businesses are merely just holding entities for assets. And in that case, you know, if the value of the business is tied more towards labor, then the data service is the right way to value it, because any increase in value is going to be so tied with the operator spouse's labor after the data service that the other spouse shouldn't have to get a cut of that. But let's say you own a business, and the business is, for example, just a holding company for rental properties. The tenant's already there, they've already signed a lease, money's already coming in, and just market performance, with the housing market, increases the value of the prospective value of the property or rents. It may make sense to choose a later date than the date of service, because the change in value had nothing to do with anyone's labor or input or effort. It's just kind of static. In the same way that a court looks at gains and losses for a retirement account when those gains and losses are passive.
Yeah, and I hope what people are understanding is just how complicated this is. And
Yeah.
there are valuation issues. There's figuring out what is the key to the growth. Is it labor or is it market forces? And there's what was known and knowable at the date of service versus what happens in the future. But one of the most difficult things for a couple to deal with is sometimes it can take a year to get a divorce, especially if you have a complicated financial transaction coupled with your divorce. And if you own a business together, then that is usually a complicated financial transaction. So, let's say you've got something like a roofing company and dad is the general contractor and mom runs all the books. If mom's name isn't on the corporate documents, then can and should dad cut mom out of the business?
You're asking my opinion, or?
Legally, can he do so?
Well, all of these, the thing that's complicated is a lot of the different issues intertwine with each other. So on one hand, if she's not a member of the corporation, there's no like ongoing duty to include that person in the operations, but there are other duties and issues that could be related. For example, the duty of disclosure, right, which is required through the court. So when you're involved in a divorce proceeding and there's a business, you're required to disclose certain information to the other party. That's going to continue regardless of whether the other spouse has an active interest in running the business. However, would be, disclosure rules are going to be more limited than if you have an operating agreement that requires a fiduciary duty. The other thing to consider is spousal maintenance. So you may kind of cut, like, depends on what you mean by cut the other spouse off out of the business. If you're the primary breadwinner and your income has historically gone into a joint account and your spouse is a stay-at-home spouse with caring for the children, if by cutting off that spouse you mean no longer providing any financial support, that's a separate issue. You can do it, but that spouse can file for temporary orders and ask for spousal maintenance. And the court may say, yeah, you don't have an obligation to include her in the business, but you do have an obligation to support her financially or him financially based on the historical, dynamics during the marriage, among other things.
And that would be the correct way to do it. The
Yeah.
court should order the owning earning spouse to pay spousal maintenance. The court should not order the owning operating spouse to maintain employment or maintain a certain duty within the company, because that's where that line is on where Title 10 and your operating agreement really kicks in versus family court, which can tell any spouse to pay spousal maintenance or to continue paying the bills in the house. But really, the court shouldn't tell you how to run your business. And this is just such a fine line. And I don't know that people always know what they can and should ask when they go to court, especially if they're representing themselves.
Right. And it's conceivable that you would want to, again, it depends on, because there are also businesses that are run jointly.
Mm-hmm.
In that case, and when I mean run, there's a difference between being an employee, which Arizona is an at-will state, employment state, which means that there's no continuing obligation to employ somebody. You can terminate somebody at any time. An employee can quit at any time, subject to certain, rules. There are some, you can't fire somebody because of their race, sex, gender, certain protected classes. But if somebody's a member of the LLC and is historic, has a similar stake as you, or even a stake, you probably can't just cut that person out completely. So it really is something where, I guess we should talk about what happens, because sometimes when you have a partnership where one spouse is involved in the business, the other isn't, and the spouse that is involved in the business has other partners or members with an equity interest, the operating agreement, which is the formal written agreement that governs how the business is managed and operates, may have a provision in there about what happens with the owner's shares or interest in the event of a dissolution, or what happens with that spouse's shares. That can get really, really interesting because things you want to look for. Did both spouses sign the operating agreement? Did one spouse sign the operating agreement? Does it even really matter? Because at the end of the day, the court, regardless, this is interesting. Nothing's impossible when you walk into a courtroom. That's why you need an attorney, right? Like anything really can happen if you're not prepared, even sometimes when you are prepared. But in most cases, the court is going to value the business and then assign an interest based on the percentage of ownership, regardless of what the contract says, right? So even if the operating agreement says in the event of a divorce, we're going to value your interest by, X, Y, and Z procedure, the court's not necessarily bound to that. Maybe
Right.
the court is bound to it if everyone signed that, meaning both spouses signed it, they had representation, and it was deemed fair, but you'd have to analyze it as an agreement that was made during the marriage, which has its own set of rules, kind of like a prenuptial agreement.
Sure. Yeah, absolutely. Any type of like agreement between parties about specific property, does it have to be analyzed as a postnuptial agreement? Or are only postnuptial agreements titled as such analyzed with the scrutiny that comes for a postnuptial agreement?
So not all agreements entered in between spouses are considered postnuptial agreements. I don't have the exact definition off the top of my head, but I believe it is something like if any agreement that substantially or significantly impacts the spouse's property or debt rights that is entered into during the marriage would be considered a postnuptial agreement. Now, there are some things that are going to be lesser, right? But the whole concept here, and then we may have talked about this before. There's this whole body of contract law. In this country, you're allowed to contract freely with people. However, the courts have looked differently at contracts that are formed between people that have other legal duties and obligations to each other. So there's something called, for most contracts between, John Smith and, Jane Doe, right? Two strangers, it's considered an arm's length transaction because they don't know each other. They don't have any other obligation or competing forces. With spouses, it's not considered arm's length because you have certain legal duties. And in fact, again, this word fiduciary duty comes to mind to your spouse. So that's something you have to take into consideration as far as contract law, because normally what may be good to do to another person who's a stranger isn't acceptable to do to a spouse, even if they signed the document.
Absolutely. So the reason I wanted to talk about this is because it's so complicated. When is the date of the valuation? Does it matter what happens before or after? What about operating the business during the actual divorce? Like in the example of the roofer, general contractor husband, and the bookkeeping wife, if there is so much conflict between the two of them that operating the business becomes impossible, then, and many times, the non-owning bookkeeping spouse ends up getting pushed out, and she gets compensated through spousal maintenance. But then when the owner has to go then hire a bookkeeper, the money available for spousal maintenance goes down. Does he still have an obligation to support her at the same level? Not in Arizona. In Arizona, after that service of the petition, unfortunately, well, or fortunately, I don't know, we don't have this concept of the status quo should be maintained during the pendency of the divorce. And so the non-owning spouse really can find themselves in a cash crunch.
Yeah, and again, you can seek court intervention on all of these things. So there's a way to resolve these, but preparation is key. Because, when you're trying to get relief from a court during the pendency of an action, so while it's going on, that's called temporary orders. And in practice, most of the time you get an hour. Sometimes you can ask for more, but in reality, most of the time you get an hour. So if you're dealing with a complicated organization, remember, this is an hour for the entire hearing, which means that you each get 30 minutes to put on your case. That involves any witnesses and exhibits. So you better be very, very prepared to make your argument, because it's very easy for the judge to be confused or not have enough information to render a decision that is favorable to you, which can kind of benefit the owner spouse, I think, to some degree.
Usually in family court.
It can go both ways, right? Because especially because again, it all depends on the business. But if you're a lawyer's going to call whatever numbers are favorable to their client to the court's attention, and maybe that's revenue, right? Gross revenue, sales, receipts, how much money is coming in the door. And there are some businesses that it can look like it's pretty darn profitable, but you have to look at the other side of the equation. What are the costs of goods sold? What are the expenses of the business? Because maybe the business has a lot of sales but a low profit margin, right? And if one lawyer is pointing out the gross sales and you never talk about the expenses, the judge may be misinformed and think there's lots of money to go around when in fact there isn't. Or you could have an attorney that focuses on the expenses, but there's no discussion about the fact that a lot of these expenses are personal in nature, right? In terms of what's reported on the tax return. So you really have to dig into these things deeply so that you can be prepared to summarize them for the court. Usually for temporary orders, like your pretrial statement, your written arguments to the court are going to be very important because you're just not going to have time to get through testimony on each issue.
I completely agree with you. And I think these are some of the hardest cases. The pretrial statement for the temporary orders on a complicated divorce is one of the most challenging things that you can do as an attorney, because you have to condense your argument. It must be brief, concise, and clear, even when it's complicated.
Yep.
And because this really is your first impression in front of a judge. So we've talked about like this very difficult period of time when you're not yet divorced. And we've talked about the date of valuation. But if you are let's take it from both perspectives. If you are the owning spouse, what do you want to do in terms of getting a valuation? Do you even want to get a valuation? Or is it better to just let your spouse do it?
I mean, so again, I think it depends. It's like the classic lawyer answer. Um, if you're going to take the position that the business has no value, um, and you think that that's a credible argument, meaning you actually believe it, uh, I'm of the firm belief that prompt and complete disclosure is better than holding information back. Because again, if you're saying the business is operating at a loss and it's true, why wouldn't you over disclose things? So you can, because you want to be able to prove that, right? And when you hold information back in that circumstance, it always makes the other spouse think that you're hiding something for a reason. Um, and oftentimes clients are, I mean, they're human beings, right? They're just uncomfortable with disclosing information to their other partner, I mean, their spouse, or they're going through divorce with. But if you really think that your business has no value, disclose everything and disclose it early, so that you can make that abundantly clear to the other side. If you think that if the business has a lot of value, you may be better off just doing nothing, right? I mean, do what you're required to. I'm not saying do nothing. Do what you're required to, but don't go above and beyond that, because uh, the judge is tasked with determining how much the business is worth, and how much the business is worth is not dependent on what you or your spouse think it is worth. It's dependent on actual accounting principles. And so if nobody's retained an expert to tell the court what it's worth, then the judge may have a hard time making a decision, which, again, not always, but usually is going to benefit the owner spouse.
Yeah, these are hard decisions. And I completely agree with you. If you think that your business has no value, or you want to you want your position to be that the business has no value, this is an interesting thing. And what it means, what you're essentially saying is, this business doesn't make more money than I would get if I were working for somebody else. In a nutshell, right?
Right. Well, there are a couple of different, this is a good time to segue. There are a couple of different methods that you can look at to value a business. The first would be like the asset approach, which is essentially looking at the book value and assigning a value to the business based on what somebody would pay in the market for the actual
Stuff.
yeah, stuff, the computer.
Let's say you've got equipment. Then
Right.
the analysis isn't, could I make this much money working somewhere else? Then the analysis might be, but what about all the vehicles you own and the equipment? Like that has a value.
Right. And so if you think about, if you own a store that still sells bicycles, that may make sense to, like, if the primary or source of your income is just selling goods,
Mm-hmm.
then it makes sense to value the inventory and
Mm-hmm.
put a lot of weight on that approach, because that's kind of how it works, right?
Mm-hmm.
But if you own a law firm, right, I've got a computer, right? You can put a price tag on my computer, but that's not really where the value is generated. You know what I mean?
Yeah, right. Or if you own a pool repair or a pool service company or a pest service company,
Right.
Yes, you've got some chemicals and maybe a car, but really what you're making your money on is this ongoing service that you get paid for, or income.
Right. And so the approach that you alluded to, which is, I think, in terms of what we deal with, the most common, is generally referred to as the income approach. And you're looking at, the earnings that the person, yeah. So again, let's say you have an auto shop repair business, and, you make $200,000 a year. and if you had to hire your replacement, you would make you'd have to pay them $100,000 a year. Well, you're kind of, by virtue of owning that business, instead of working for somebody else doing your same job, you're making an extra $100,000 a year. That's what's getting capitalized in terms of like that's what is being assigned value in terms of the overall value of the business. Or there's a different way of looking at it in terms of what's called discounted cash flows, basically trying to define in real time what the present value of the money that the business is going to take in is. And there's reasons why you would use different options, but those are the most common. And then there's also what's called the market approach. And this is really good in industries where sales and transactions of certain types of businesses are very common. And this is looking at like, think of it kind of like, and this is oversimplified, but in real estate, you have the comps that the realtors, they look at what other houses in the neighborhood sold for recently. And if you have enough volume in sales, you can reasonably predict what the business would sell for. So in certain industries where businesses or business interests exchange hands frequently, it's really easy to look up the data and assign a value that way. So those are the three major approaches. Oftentimes it's kind of a combination of all of them.
Yeah.
Right?
So you're looking at all these things, like how much does my business own in stuff? How much does my business earn in income? How much does my business have coming in contract revenue? And if you're going to argue that it's worth nothing because those things are low, then I agree with you completely. You want to disclose as much as you possibly can early, because it does not make sense for you to pay $10,000 for a business valuation. And there's always a risk that the business owner could be ordered to get a business valuation and pay for it. So to mitigate that risk, you want to be able to give everything you possibly can to the other side, so that if they ask for a business valuation or they ask you to pay for it, you say, hey, this is not necessary. You have everything you need. It's not worth it. If you want to get a business valuation, you do it. But if the other spouse can credibly argue that you are withholding information, I think you're much more likely to be ordered to pay for that business valuation.
Right. And if you are the spouse on the other side, you want to do everything you can to get a valuator appointed, because again, ultimately, if the judge doesn't have an expert, I mean, somebody who's qualified from an accounting perspective to tell the court what the value of the business is, then you're up the creek without a paddle. Really on either side.
So ask early. If you are the person who does not have the business, but you know it's creating buku bucks, or you know it owns expensive specialized equipment, you really probably want to file a motion very early on in the case, asking for an evaluator to be appointed and the owning spouse to pay for it. Waiting too long is not your friend. Now, if you have a business and you know it's worth a lot, then there's risk. You know it makes more money for you than you would make otherwise. You know you own expensive equipment. You have risk. And if you know that your spouse is going to get a business valuator, then you really need to be thinking about who you're going to get to value your business, because there's a lot you can do to influence the value of your business based on the valuator you choose and the experts you choose.
Right. I agree with that. Also, oftentimes business owners will point to tax returns because people aren't always, well, first of all, accounting principles are different for tax purposes than they are for like the purpose of valuing a business in terms of true economic benefit. For example, oftentimes on taxes, you can deduct depreciation, you can deduct all kinds of, really intangible costs. But sometimes, I've seen a lot of sole proprietorships, so business owners who are just on their own report low income on their taxes. But then you start to look at their affidavit of financial information or their bank statements, and you're looking at, okay, you say that you made $20,000 last year, but your mortgage is $2,200 a month. So how does that make sense? Because like that's more than your total income.
Right.
And that's when you know that there's some issues there in terms of the accuracy of the documentation, which means that the valuation is going to be a lot more expensive, but also probably very necessary. Um,
Yeah, and I'll tell you, that's a red flag for judges. When
yeah,
judges see tax returns that are very low and lifestyles that are very expensive, um, I've seen judges in that case immediately say, hey, this isn't honest. I don't trust this. And now there's already a presumption that you're dishonest. So you really want to get out ahead of that if you possibly can.
absolutely. Yep, absolutely.
And one of the ways you can do that is by settling. One of the ways you can do that is by settling on a temporary basis and not bringing that in front of a judge before you go to trial, before you're ordered to a business valuation, before you're ordered to spend a lot of money. So before you make these decisions about what to do in litigation, you really want to make sure that you hired an attorney like Darren, who knows businesses inside and out. And then you want to make some strategic decisions about how to mitigate your risk.
Yeah, absolutely. And the other thing that's important to consider is that you can be really creative in settlement discussions when it comes to businesses. And the court is usually pretty cookie cutter. Um, so what I mean by that is, what is going to happen if you go to trial, right? Conceptually, the court could, in theory, order the parties to sell the business, but that's very rare.
Oh yeah.
Very, very rare. And again, it would depend on the type of business. So that's not really a viable outcome. Plus, it doesn't really give you any kind of advantage over settlement unless the terms are horrendous, because you have no idea what you're going to get until it sells, right? Which is kind of, you're in the same framework as just trying to reach resolution on the amount. Um, More than likely, the court is going to assign a value and then enter judgment for that value. Now, if the rest of the community, meaning the rest of the property, has enough equity to cover the cost of the buyout, then there's no risk or concern there, because if the court determines that that your share of a business is $200,000 and your home's got $500,000 in equity, well, we can just offset that and guarantee that you get your piece of the pie. That is the ideal scenario.
Mm-hmm.
But if the rest of the community doesn't have enough assets to cover the potential value of the business, then what you may end up with is a piece of paper that says the business owner owes you money, right? Which can create its own set of problems, and you can end up in court trying to collect on that piece of paper. Whereas in settlement, you can really define what is the amount of the buyout, what are we going to offset against each other, what are the payment terms, right? And what are the remedies if somebody defaults.
Mm-hmm.
You can be a lot more creative and comprehensive in
Mm-hmm.
terms of not only determining what the value is, but also how you're going to actually recover it, because it's few and far between where people on a business that has substantial value, where they have enough cash sitting around to just cut the other person a check. If that's you, great, come see us, we'll take care of you, no problem. But
okay, one more question. I know we're going long, but it's so interesting, and it matters so much to people who are in these situations. But one more question. Let's say you're in a position where you get a judgment against you to buy somebody out on your community business, and you've got a building that you own that's your separate property that has $500,000 of value in it. Can the court order you to sell your separate property or give a spouse an interest or lien on somebody's separate property to satisfy a community property judgment?
yeah, I think so. I think it's debatable, but I think the court can do it.
Yeah, okay. I think you're right, because I know for sure if you have a spousal maintenance judgment,
You certainly put a lien.
you can get a lien on somebody's retirement account. So even, yeah. So, I mean, some way or the other, that money is probably fair game. Okay, this has been fabulous. I know we've gone long, but it's been a fabulous discussion. Next time, I want to talk to you about astronomical spousal maintenance orders that are non-modifiable and what people can do about them, because we've had a couple of those come in and those are right up your alley as well. So we should definitely talk about that. But thank you so much for your time today, Darren, and we will talk again soon.
Absolutely. And I'd like to kind of revise, because I just took a look at the statute. The court
Oh, that's what you were doing.
it can put a lien on separate property to secure payment of certain things, including, allocation of community property. The question is, how do you get that lien to turn into a sale of the house? And I think eventually you can get there, but you have to go through other steps.
Okay, so that's important. That means if you have separate property, it's not fair game in a divorce. It's not fair game. There's a way that the non-separate property owning spouse might be able to attach a lien, or the court might be able to attach a lien that they might eventually get paid on. But it's not like you can be forced to sell your separate property to buy out your spouse. That's a big deal. It's important.
Yeah, and I mean, eventually, if somebody, there are ways that you can take a lien and force somebody to sell a house, but you have to go through a different.
Right. It's like a whole foreclosure process, right?
Yeah. Plus, you also have to, sometimes you ask the judge to do something and they just do it. And if the other person doesn't object, then it ends up happening.
What if that person were to sell their separate building and have money in the bank, but it was separate money? Could the court order you to give that to them?
Yeah, the court can definitely, I think, freeze the transaction and have the funds held in trust. I think so. In the reality is, if you're trying to make moves to try to avoid payment like that, it may end up not being a good thing for you, depending on the circumstances.
Yeah, but it may also put you in a position where you can negotiate a buyout that works for you, or that is something you can live with, as opposed to just handing over all your cash. So it's just important that you know all of the options, and so you can be creative and come up with hopefully a solution that works for everybody. Because hiding money never works, but structuring your settlement in a way that you can all live with is, in my opinion, a best case.
That should be the goal. That should definitely be the goal. And sometimes people just disagree. Somebody thinks the business is worth $2 million. Someone thinks it's worth 200, and that matters. And it's hard. In that case, the judge is there's no middle ground, right? There's no reasonable compromise.
Yeah, that's tough. Then it's the battle of the experts.
Yeah, and in that case, it just makes sense to put your head down and get everything ready to go to trial. So next time we can talk about what happens if there's a separate business and it goes up in value during marriage.
Ooh, yeah, that's true. That's a whole nother topic. We will talk about it. All right. Thanks, Darren.
All right. Thank you, Billy.
Bye.